Is your out-of-state property going to drag your heirs into multiple probate courts? You set up a California will thinking your estate plan was finished. What were you thinking? But if you own real estate in California or other states, your heirs will most likely face probate or a second probate you never saw coming. A will doesn't avoid probate, not in California, not in Nevada, not anywhere. This video shows how overlooked detail could force your family into multiple courtrooms and how a simple fix can spare them the stress. So your heirs skip the legal red tape, keep more of what you have built, and never step foot in any probate court. Hi, I'm Talai, a trust and asset protection attorney and founder of Talai Law Offices. Real estate must be probated in the state where it is located, no matter where you lived when you passed away. Your California will does not magically transfer an Arizona vacation home or a Nevada rental property. In fact, any will, still will require probate. That means if you die with property title in your own name in another state, your family might have to open up a second probate case there. Us lawyers call this an ancillary probate, meaning an extra probate in another jurisdiction. The result, one estate, multiple probate judges, more attorneys, more legal fees, and much more stress for your loved ones. You might be thinking, why can't my California probate handle everything? Here's why. Each state has its own courts and laws controlling properties inside its borders. A California judge cannot change title to a real estate in Texas or any other state. Likewise, a court in Oregon won't honor a California order to transfer land in Oregon without its own proceeding. That is why ancillary probate exists. Each state insists on handling real estate within its borders through its own process. So if you live in California and own a cabin in Arizona, your executor must open an Arizona probate for that cabin in addition to the California probate for your other assets. Going through probate once is hard enough. Going through 2 or 3 is a nightmare. Each state requires its own court filings, fees, and procedures. Your executor may have to hire an attorney licensed in that state, a very good decision. Some states require appointing a local resident as co-administrator, adding another layer of complexity. And don't forget the cost, right? California probate can run 3 to 4% of the estate value. Add another probate in Arizona or let's say in Texas, and now your heirs could be paying tens of thousands more, money that should have gone to them. Here's the good news. You can prevent all of this with the right estate planning in place. The main strategy is using a revocable living trust and making sure your out-of-state property is titled into the trust. Also, your property in the state should be titled in the trust as well. A living trust holds title to your assets during your lifetime and transfers them to your heirs privately after you've passed away without the need of any court involvement. That is true for property in California, and it's true for property in any other state. It doesn't matter that your revocable living trust is written based on California law. That particular trust can hold properties in any state, and as long as the title is under the name of your revocable trust, it will avoid probate no matter where the property is physically located at. If your trust owns your Arizona rental property, that property is no longer in your individual name. At the time you pass away, your successor trustee can distribute it according to your trust terms without opening up a probate in Arizona. No court, no multiple probates, just a smoother transition for your family. Creating a living trust is really only step one. Please keep that in mind. Just having the trust is not enough. The crucial next step is funding the trust, transferring ownership of your assets into the trust. If you forget to deed your, let's say, Arizona condo or your Nevada rental property or your home in Los Angeles, those properties are still in your individual name, and that means probate in those estates despite having a trust. This is where many people drop the ball. Unfortunately, the trust only works for assets that are properly transferred into the trust. For real estate, that means recording a deed in the name of your trust. If you own property through an LLC, then what you want to make sure you do, you want to make sure the membership interests of that LLC have been assigned to your trust. If you own a corporation, what you want to do is you want to make sure your shares have been transferred into the trust. Yes, California attorneys also prepare what is called a pour-over will as a safety net, but keep in mind a pour-over will still goes through probate for any assets left outside the trust. It is a backup plan, not a substitution for proper trust funding. The goal is simple. Move all significant assets into your trust while you're alive so your heirs avoid probate entirely. Setting up and properly funding a trust is the cornerstone of avoiding multiple probates and protecting your family from needless stress and expense. That is why I want you to join me in my next video, The Truth About Funding Your Trust and What Happens If You Forget It. In that video, I will walk you through what can go wrong if you don't transfer assets into your trust and the practical steps to make sure nothing falls through the cracks. And if protecting your heirs is important to you, and I'm sure it is, you don't want to miss it. See you in the next video.